Are you among the 60% of Americans without a will? This isn't just a statistic, it's a wake-up call. Discover how a living trust can be the solution to protecting your assets and securing your legacy. Hi, I'm estate planning attorney Mike Smith with Smith Barid LLC, and I'm one half of the estate planning guys. Now, many people I've found delay estate planning because they think, oh, it's so complicated, or they have misconceptions about the necessity for it. They say, oh, I'm married, my spouse can just step in and take care of things. If something happens to me, I don't need to worry about estate planning. And nothing could be further from the truth. The risks of not having a living trust plan in place include things like delays for probate court when a spouse passes away or when both of you die, public access to the information about your estate. A lot of probate courts now are online, so people can very easily find out information about what's in your estate and who your beneficiaries are. And then you got the other thing that comes up more often than I'd like to see, but that's disputes among heirs or beneficiaries. So disputes among the people left from your family over, what they're going to get from your estate. A living trust provides a private and efficient way to handle your estate. And with a living trust, you can ensure that your assets are managed according to your wishes without the need for any court intervention. And one of the key things to understand about avoiding that court intervention is, first of all, it's a time delay because your attorney that you hire to handle probate, they don't control the way that the court works. And so some courts are efficient, others are just frankly not. So in addition to the statutory requirements for notice and time periods, there's also the fact that, the court could just be inefficient, and that could lead to a big delay in moving forward with your probate if you have a will or you have no plan at all. And the other thing that can happen, so when you file a probate, you have to notify everybody about the contents of the will, and it's not just people that are necessarily named in the will, but also your heirs at law. So people who may take from your estate if you died without a will. And these could be people that you may have wanted to disinherit, and you might not want them to know what's in your will, but they're required to receive notice. When you notify those people about the filing of the will, if they don't like what's in it, they have an opportunity to just file an objection. And in my experience, it's generally very easy to do that. I've seen people file objections without attorneys many times just by writing a letter to the court and saying, hey, I don't like this will. And the court oftentimes will kind of bend over backwards to help unrepresented individuals who are appearing in probate court. So it can be a sort of an invitation for a fight, an invitation to delay how long it's going to take to wrap up your estate. So with living trust, you avoid all that stuff. You don't have to notify anybody except the actual beneficiaries that you intend to receive something from the trust, and you don't have to file anything in court. So it can be a great way to, really shortcut the process, get things handled more efficiently, save money, and save a lot of time. So how do you set up a living trust? Well, it involves a few key steps. The first one is you need to hire a lawyer. I'm not going to mince words here. The online will and trust applications that are out there, they're pretty much garbage. I've had to fix a lot of messes that were made by folks who had bought some online downloadable form or used some sort of service out there that's not an attorney. The reason you hire an attorney to draft your will is the same reason that you hire a doctor when you're sick. You don't know what you don't know. And the fact is that estate planning is complex. There are a lot of different areas of law that are involved in estate planning, a lot of considerations that need to be brought to bear on your particular circumstances. And a computer program is not going to do that for you. So my opinion, I am an attorney, but you really need to have an attorney to draft the documents for you to help you through the process of estate planning. So first thing is you hire an attorney. The next thing is that the attorney will, after consultation with you and an understanding of what it is you're trying to accomplish with your estate plan, will begin to draft up your documents. And there are multiple documents involved in a trust plan. It's not just the trust. The trust is sort of the central document, but you're going to need a pour-over will. You're going to need an advance directive for healthcare or some sort of healthcare proxy. You're going to need a power of attorney. So there are a number of other documents that are involved in a complete trust plan. And the attorney will walk you through drafting that, helping you to design the plan. The attorney will draft the documents for you, not walk you through that, but they'll walk you through designing the plan and helping you make decisions about who should serve in what roles and how things should be structured. And then the attorney will take that information and draft up your documents. And once the documents are drafted and you've reviewed them, then you'll execute the document. So you'll sign the documents, and that's when it all becomes effective. So if you're interested in learning more about how we help families protect their legacies from probate, predators, and government intrusions, I wrote a free book titled The Ultimate Gift that lays it all out. If you'd like to pick up your free copy of The Ultimate Gift, simply click the link below, give us your address and a credit card for shipping and handling fees, and we'll ship it out to you free of charge. Read The Ultimate Gift so you can learn how to protect your family. So at that point, your trust springs into existence, and you can then undertake the next step, which is what we call funding the trust. And that's actually getting your assets into the trust. So transferring assets into the trust, attorneys refer to that as funding the trust. And that includes everything from real estate to bank accounts. Really, I kind of think of it as almost everything you own. There's certain assets that you wouldn't want to put into a living trust, and I've done other videos about that. But, basically I think of a living trust as a bucket, and you put essentially all of your assets into it so that the trust will then manage how those assets are distributed out when you pass away, or if you become incapacitated, how things are going to be managed on your behalf. The third step is managing the trust. And as the initial trustee of the trust, you're in control of the bucket. So you're holding the handle to the bucket, and you can do whatever you want to with the assets that are in the trust during your lifetime. You've got the flexibility to, buy or sell them, invest in, whatever you want to, Bitcoin or options or whatever it is you want to do. And then you can pledge them for loans. You can gift away assets if you want to, whatever you want to do with the assets during your lifetime when you're serving as the trustee. And then after you pass away, the person or entity that you've chosen as the successor trustee will take over the handle to the bucket, and then they will follow the instructions that you've left in the trust for how you want things to be distributed. So that's what the trustee's role is, the successor trustee after you pass away. So a living trust has got tons of great benefits. We've talked about avoiding probate, but that's not the only thing. It allows you to maintain control over your estate, even if you become mentally incapacitated. So if you had a stroke or you developed Alzheimer's disease and you can't manage your own affairs anymore, the trust, the bucket holds all the assets, and the person that you've chosen will just take over the bucket and manage it on your behalf. Additionally, it gives you privacy. The trust is a private document. You don't have to share it with anybody. It's not filed at any courthouse, and nobody has a right to read the trust other than beneficiaries of the trust. It also gives you great flexibility. As I said, you can do whatever you want to with the assets that are in the trust. During your lifetime, you have full control, and then after you've passed away, your successor trustee has control over the assets in the trust without getting permission from anybody, getting any hassle from banks or anybody else. You can do whatever it is you need to do with those assets while you're alive, and then your successor trustee after you've passed away. So, whether you're a young couple planning for the future, planning for future children or children that are on the way, or if you're an elderly individual and you're looking to, manage your affairs in a private way, a living trust can provide the necessary tools to secure your estate. So let's explore a couple of real life scenarios where living trusts have been pivotal. I had a family recently where the husband passed away and they had a living trust in place, and it was just the smoothest situation. There was no probate that was necessary. The wife just took over the trust after he passed away, and she was able to live her life without having to worry about going through any kind of probate or deal with any hassles after he passed away. And she is getting older now. She has developed Alzheimer's and just, kind of can't manage things for herself anymore. So she named her daughter as a co-trustee on the trust, and now her daughter can step in, pay whatever bills there are, take care of making investment decisions and all the things that she needs to do for her mother without needing to go to a probate court and ask for permission, without any hassle or time delays, and no public interference. So it's a great way to take care of those that you love during your lifetime, take care of yourself, as well as set things up for when you pass away to make it as easy and efficient for your family to wrap up your affairs for you. So if you're interested in setting up a living trust or you're looking for information, you can contact us at Smith Barid LLC. Our website is smithbarid.com. That's SMITHBARID, like barid.com. Tons of information on our website, as well as some free materials that you can download. Or you can give us a call if you want to have a chat with somebody on my team about planning for you and your family. But the one thing I want to leave you with is don't wait to make one of the most important decisions you can for your family's security. Don't be part of the 60 to 70% that don't have a plan. Living trusts are about more than just asset management. They're about peace of mind. By setting up a living trust, you can ensure that your legacy is preserved according to, exactly what you want. And you can avoid the complications of probate, and you can minimize estate taxes, and you can make things much simpler and easier. So start planning today to protect tomorrow. Thank you for watching, and remember to subscribe for more insights on estate planning.